Hello, I am P.R. Krishnan. Welcome once again to my presentation, episode number 6 of Inheritance Law. This will be the last video on will as an inheritance instrument, and then we will move on from here to the next of instruments on succession laws, like succession laws. In the last 5 videos, we saw from the beginning the prerequisites to making a will, to actually making the will, the next registration, and then probating. We also saw the consequence of making a will or not making a will, getting it registered and or not probating it. Now in this video we will touch upon the various legal acts that come into play. We will also touch upon daughters and HUF with regard to will and a few general matters. Various acts. There are few acts that guide succession. First, let us talk of Hindu Succession Act. The act covers Hindus, Jains, Sikhs and Buddhists, etc., where the testator dies intestate. That means he has not made any will and he dies. This act was basically for Hindus, but due to its wider connotation, this act also covers Jains, Sikhs, Buddhists. And when there is no will, but when there is will, the Indian Succession Act is applied to Hindus, Sikhs, Buddhists, Jains. In case of Christians, Parsis or Jews, the Indian Succession Act will apply irrespective whether there is a will or there is no will. For Muslims, their personal laws will cover Muslims. Over a period of time, while Hindu laws have changed from a patriarchal base to empowering women, little has changed in the Muslim laws. Muslim laws are more rigid. Christian laws in comparison to Muslim laws are more liberal. So we have three distinct laws, which are Indian Succession Act 1925 only applies where there is a written will, that is, it is a testamentary succession. It applies to Hindus. Here everyone gets as per the will. Section 31 to section 49 covers Christians and Jews. Then you have the Hindu Succession Act 1956 and Hindu Succession Amendment Act 2005. It applies to where there is no will and applies to intestate situation or intestate succession to Hindus, Buddhists, Sikhs, Jains. Hindu laws are generally codified. Now let us come to Muslim law. Muslim personal law application 1937, known as the Mohammedan law, uses the Shariat Act 1937 for Muslims when a person dies intestate. Mohammedan laws followed are Quran, Hadith, Ijma, Qiyas. Probating. The will need to be probated if it is executed by Hindus and Parsis. Even if you are staying outside the limits of NCR, Mumbai, Chennai, Calcutta, Assam, Bihar and Orissa, and if you are making a will as a resident there but have immovable properties here in these 7 places, then probating is compulsory, mandatory. For Muslim, probating is not generally required. Muslim laws are also not codified. For Christians, till 26 May 2002, probating was required and then they have been given exemption. Muslims, different personal laws are there for Shias and Sunnis, and such laws are not codified in any statute. Now let us look at in deep the Muslim laws. For Sunnis, generally Hanafi law is mostly followed in India. Or personal law restricts legacies to maximum 1/3 of the estate, remaining after taking care of funeral expenses, outstanding wages of domestic servants, etc., and debts. The remaining estate is required to be distributed amongst legal heirs, and there are three types of legal heirs: sharers, residuaries, and kindred, distant kindred. So that needs to be distributed that way. Let's take an example. For example, if mother and son are left by a deceased, mother becomes a sharer and son is a residuary, basically residual. So mother gets 1/6 and son gets 5/6. So sharer and residuary distinction I have shown you. Now if there is a daughter, then the rule says the son should get double to what daughter gets. And both son and daughter are residuaries, along with father, and also son is son, daughter's son. If two sons are there, then both sons will get double to what daughters get. They are equivalent to class 2 heirs. They will get the remaining estate after meeting the requirements of sharers, that is mother. Distant kindred. Now they are the other relatives who are neither sharers nor residuaries. They will only get if there are no sharers or residuary. Meher. There is a dowry promised by husband, would be the first charge. Priority debt. Priority debt. If the same has not been paid by the deceased during his lifetime. Under Sharia law, if divorced, the woman gets maintenance from her husband, reasonable provision after divorce, and the right to meher, which is the dowry agreed during marriage. In case of death of husband, the woman gets 1/4, that is 25%. Now this 25% is sacrosanct, fixed. If the deceased had two wives, this 25% is divided between both the wives. If he has three wives, then it is again divided between three wives. So each three will get about 8.33. Now that's not the end of it. The total remains at 25. Now this assume there are no children. If there are children, then this becomes 1/8. Why 1/8? Because 25% is 1/4. So if there are children, then they get 1/8, and 1/8 will get divided between 2 or 3 wives. Effectively, whichever way you see, a total of 25% of wealth is only distributable. Of the balance, mother gets 1/6 of the wealth, that is 16.66%. Let's also touch upon Christians. As regards Christians, the widower inherits 1/3 share, and the balance goes to the lineal descendants. In case there are no lineal descendants, then 1/2 goes to the widow, and the balance to the other relative, that is prescribed as kindred or kins. Among the lineal descendants, each child, or if predeceased his children, collectively will get equal share. In the kins, the first preference is given to the father, and in case he is predeceased, then mother, brother, and sister. If they are also predeceased, their children. So this is something about the various acts. Now I will touch upon daughters and HUF. I mentioned about daughters a little bit earlier in the previous chart. Now I will cover a little more about women in general. First, under the Hindu laws, a daughter has equal right like her siblings in her parental properties. This has been made retrospective effect in the Amendment to Hindu Succession Act 2005. Both mother and son wife are class 1 here, and so they are entitled to equal share in case of division of property. Sister like father falls under class 2 here, hence only if there are no heirs under class 1, she can claim with her brother and father. Daughter-in-law has no right over parents-in-law's properties. A divorced woman can claim alimony and maintenance, but not property of her husband. However, nowadays we see the courts are coming out to the rescue and asking the husband to provide for accommodation or partition of a house, or if he has more houses, one house is to be given. In the case of remarried woman, if she gets her partitions before remarriage, she keeps the part under section 24, else she is not entitled to. She is expected to give up her claim. Second wife is polygamy and not allowed, so no entitlement. If it is after death or divorce of the first wife, then she will get entitlement as a wife. Under Christian law, which is similar to Christians, Jews and Parsis, for daughters it is akin to Hindu law. For wife, if she is widowed, under Christian law the woman gets 1/3 of the property, balance is divided amongst the children. Under Christian law, as another as a mother, she gets nothing unless the child is unmarried or has no children, in which case she gets 1/4. Under Muslim law, the entitlement for women is half of what men get. Under the Sharia, a married woman enjoys total ownership of her property plus maintenance plus reasonable provision and meher. 1/4 is given on death, and these have been discussed above in detail. Mother gets 1/6 plus maintenance, divorcee gets meher and nothing from the husband. A second wife has legal status as a wife and enjoys everything as a first wife. Now, under Hindu, women have been given rights on testamentary property even before 2005. Under the amendment, it was made retrospective. Under the amendment which was made in 2005, their marriage has no consequence. In case of HUF, the son-in-law becomes member of HUF but is not a co-partner. But wife is a co-partner, therefore her share in the property he can acquire. Others. These are just for information how to find if there is a will at all. One way is, if you think there is a will, you have to you may have a family lawyer or attorney. One way is to ask him. Second is, you can check with close family friend or supporter if they are aware of it. Otherwise, you have to check with the registrar and do a search of records, or check the probate court's records relevant to the jurisdiction where the person lives. Nowadays, you can do everything online and pay online in Mumbai, as most records in Mumbai are uploaded and put it up online. Inheritance tax or estate duty. There is no inheritance tax currently in India. Estate duty was started in 1953 but abolished in 1985, so that is also not in existence. But if a property is given to a spouse, even if any of this tax is levied, still for transferring to spouse there is no inheritance tax. Testator. Testator and witness, as I told you, must be present at the time of registration. I am just wanted to reiterate over here. In some cases, registrar may come home, but they charge for the service. In any will, it should state in the beginning, a will is being made, identify himself, and in the end he must state that this will is a last will and testament. Questions first raised, if a blind man can make a will. Yes, there are rules for that. One of the ways when will gets cancelled is when Parsis and Christians get into marriage. Marriage of testator cancels any will. Living will, for those under medical treatment and likely to die, can make a living will to not to put on ventilator or palliative care and let them die. In a will, when you do, please provide for future additions or assets missed out. A general clause is included in a will for residual properties, assets, miscellaneous assets that were missed out, which specify who should receive residual assets, and similarly a general clause is added for all future assets. Friends, in today's video we have covered mostly about women and their inheritance rights under different circumstances. The various acts and the details thereunder, which are very important to know for those falling under different religions and few other FAQs. That's about it. With this, we have concluded our presentation on will. As you can see from all the presentations 1 to 6, much of your doubts would have been cleared, and it is also not difficult to prepare for a will now. I think by now you should be able to prepare almost everything you know. Good to know, will is the most cheapest way of transferring assets. There are others which can solve 70 to 80% of the issues, but not all, and particularly immovable properties and businesses. Again, that is also very costly compared to will. So we shall be discussing those in the next 3 videos, and that includes Succession Act, legal heir certificate, gifting, nomination, relinquishment, etc., etc. Those presentations read with this presentations on will, the 6 presentation on will, and the 3 presentations on the others should complete the law of inheritance. Friends, if you have liked the video and presentation, please do press the subscribe button and ring the bell. Please leave your comment. Thank you for watching the video.